So please note that. So under the Code of Civil Procedure Code, the courts are not defined. Now in the the creation of courts is a state subject. So under the Constitution of India, it is a state subject. Every state can create civil courts or criminal courts. Mostly the civil courts are set up in the city of Mumbai in Maharashtra under the Bombay Civil Courts Act of 1869. Now it is the Maharashtra Civil Courts Act 1869. Please note that. Under the Civil Courts Act, we have a district court. District courts, as you know, are established under Article 233 of the Constitution of India. So it is the Constitution, the constitutional court such as Supreme Court is established under Article 124 of the Constitution, and high courts are established under the provisions of Article 214 of the Constitution of India, isn't it? All of you know that here. Then the district court is constituted under Article 234 of the Constitution of India. Please note that here. But whereas the other district courts and other courts such as civil judge senior division, junior division. So when you open the Maharashtra Civil Courts Act, you will find classification of courts. Number one, the district court. So for the purpose district court, for the purpose of city of Bombay, the Bombay High Court exercising powers under OOCJ, ordinary original jurisdiction, is a district court. Please note that. Don't be confused when you say that district court Bombay, you don't say city civil court, small causes court. They are not district court. They are only civil courts. City civil court, small causes courts are branches of civil court. Whereas the Bombay High Court exercising jurisdiction under OOCJ class 10 of the latest patent is a district court by virtue of section 2(4) of the Code of Civil Procedure. Now under the Civil Courts Act of 1869, you will find district court in section 5. Then you will find joint district court in section 12, joint district court in district court, then additional district court in section 14. Then the classes of civil court you will find in section 22, number of subordinate civil courts in section 21. That deals with the subordinate civil court. Section 24 deals with the classification of the civil court. One is a junior division, another is a senior division. Now all of you know that. Now in order to determine what is the jurisdiction of the civil court, so you can only file a suit by determining the valuation. Now in Maharashtra, we have got a enhancement of pecuniary valuation act. Please note that here. Under this act here, the civil judge junior division has got now jurisdiction up to 5 lakhs. Please note that here. You should remember as a young lawyer, as a student, the jurisdiction of a junior division, civil judge junior division is 5 lakh. Now the Bombay High Court, by virtue of some notification recently, has enhanced the jurisdiction of a junior division up to 7.5 lakh, provided the judicial officer is of 10 years. If he has got 10 years experience as a judicial officer, he is permitted to conduct trials with regard to suits up to 7.5 lakh. Otherwise, a judge below the age, below the 10 years experience, he is confined to 5 lakhs jurisdiction. Okay. Then second comes the civil judge senior division is having unlimited jurisdiction, on par with the district court. In the city of Mumbai, after 10 crores, city civil court has now been given from the year 2022. Earlier it was 1 crore, now it is 10,000, and now it is 10 crores. City civil court under the 1948 Act. Please note that city civil court comes under 1948 Act. Whereas in the Bombay city, the small causes court, which is performing dual duties both under the Rent Act Code and non-Rent Act Code. For the purposes of a Rent Act, Section 33 will come read with Section 41, 42 of the Presidency Small Cause Court Act. And those non-rent act cases like summary suits and general suits will be falling within the ambit of Section 18 of the Presidency Small Cause Court Act. Now, the jurisdiction, such as summary suits, general suit, small causes court can try up to 25,000 in the city of Mumbai. Please note that 25,000. Now, the 25,000, city civil court up to 10 crores, high court is unlimited. Similarly, the district court and the civil judge senior division has unlimited jurisdiction. And appeals against the orders of a civil judge senior division will go to the district court where the valuation is up to 1 crore. District court. And above 1 crore, the appeal would lie to the High Court under Section 96 of the Code of Civil Procedure. Please know that here. The appeal provision to both the District Court and the High Court are similar. Section 96, appeal from judgment and decree, final decree. Now, appeal from orders are dealt under Section 104 of the Code of Civil Procedure, read with Order 43. They are appeal from orders. And the Court of Small Causes Court has its own appellate powers under Section 42 of the Presidency Small Cause Court Act. Now, for the purpose of rent control legislation and suits under the Transfer of Property Act, for example, a landlord and tenant relationship, a landlord wanting to evict a tenant, or a tenant wanting to seek a declaration of tenancy, or some rights under the in respect of a tenanted demise premises, that he will have to file a suit in the Court of Small Causes Court by virtue of Section 33 of the Presidency Small Cause Court Act. There the jurisdiction is unlimited. Now the suits which are categorized in the Small Causes Court under the entire CPC is now applicable by virtue of Section 8 of the Code of Civil Procedure, read with Rules 122 of the Bombay High Court of the CPC. Now, the suits are filed under Section 33 of the Presidency Small Cause Court Act and Section 41 of the, Section 33 of the Maharashtra Rent Control Act, landlord and tenant, where the Rent Act is applicable. And under Section 41 of the Presidency Small Cause Court Act, where the suits are under Transfer of Property Act, namely, you give a quick notice under Section 106 of the TP Act for termination of the lease, that the lease has been expired by efflux of time in matters, non-rent act matters, where the rent act is not applicable, though there's a land relationship of landlord and tenant exists. Now the valuation is unlimited. Here the Small Causes Court has jurisdiction which is totally unlimited. But whereas a summary suit, a civil suit, if you want to file in the Small Cause Court, the jurisdiction is only up to 25,000. If you want to just go for plain recovery of rent, or distress warrant is sought to be executed against a tenant, 25,000. But for recovery of premises which are hundreds of crores, it is the unlimited jurisdiction under Section 33 of the Small Causes Court Act. And if you are evicting now big suits against petroleum companies and a company having share capital of more than company or 1 crore are filed by the landlords in the Small Causes Court. So there are hundreds of crores of property. There are suits under Section 41. The only requirement is that you have to give a quick notice under Section 106 TP Act. Whereas under the provisions of the Bombay Rent Act, Maharashtra Rent Act and 1990 now, you are not required to give quick notice of termination of tenancy except for forfeiture under Section 15 in view of the Supreme Court judgment in Danpal Chettiar versus Yashodama Yammal. That is AIR 1979 Supreme Court, page number 1749. You should remember the judgment. This is a landmark judgment. Your termination notice is not required because even if you give termination notice, nobody bothers to vacate. So you can straight away file it. But where arrears of rents are sought to be claimed for more than 6 months, the tenant has committed flagrant violation and not paying rent to you, then you are required to issue forfeiture notice under Section 15 of the Maharashtra Rent Control Act, read with Section 106. That is 90 days notice you are required to give to the tenant. You are hereby called upon to pay the arrears of rent, failing which you shall lose protection and you will be liable to be evicted. That is the only provision, Section 15, which mandates you to give a notice. Okay. Otherwise, for filing a suit under Section 41 of the Presidency Small Cause Court Act, the The mandatory requirement is 106 notice is required to be given for termination of a lease if the lease is not expired by efflux of time. There are Supreme Court judgment which clearly says that if the lease is expired by efflux of time, there is no need to give termination of notice. That is covered under section 111 of the TP Act. How lease is determined, in what cases. So that is the jurisdiction in the city of Mumbai. That is the Bombay High Court original jurisdiction, which entertains civil suits up to more than after 10 crores, unlimited jurisdiction. The examples of suits which come to the High Court in the OCJ as on today are: number one, testamentary suit. Under the provisions of the Indian Succession Act, you are read that here your grandfather or grandmother left a will in your favor. Okay, when a lift is left, your will after the death, you are required to obtain a probate. A probate can only be obtained by approaching a district court by virtue of section 264 of the Indian Succession Act. Now, for the purpose of obtaining a probate in Bombay city, it is the Bombay High Court where you are required to file a probate petition under the original jurisdiction, and it is also known as a testamentary jurisdiction. Please note, this is one jurisdiction where you directly approach the High Court. The second branch of cases which you approach the court are money suits, or a suit for specific performance of a contract under the Specific Relief Act under section 10, that the defendant has committed breaches of the agreement and is bound and liable to perform the terms of the contract, or that for a declaration that the agreement has been duly rescinded or extinguished. Such a suit, if the valuation is about 10 crore, it will come to the Bombay High Court directly. Please note that. A landlord and tenant suit will not come to the High Court. Licensor suit will not come to the High Court. They will go to small causes court. Similarly, a suit against gratuitous licensee or a paying guest, they are all coming and they are permissive users under section 52 of the Easement Act. They will go to the court of small causes court under section 41 of the Presidency Small Cause Court Act. Please note that here. And the High Court for the suits, which I will give example, the suits under the provisions of Trademark Patent Act. Wherever the statute uses the word district court, it is the High Court. If there is an infringement of a trademark, infringement of a copyright, or in any of your intellectual property rights have been violated, you cannot go for enforcement of those rights or claiming damages to City Civil Court or Bombay High Court, even if the valuation is 1 lakh or 2 lakh. It is only the exclusive jurisdiction of the district court under those acts. Please note that here, Bombay High Court, you have to file a suit. The original jurisdiction will come into play. Then another jurisdiction which you come to the Bombay High Court under the latest patent clause 10 directly is the under the provisions of admiralty jurisdiction. Admiralty jurisdiction. Suppose you have dispatched good to USA or foreign country, Arabian country by ship. The shipper has not delivered the goods for reason A, reason B, reason. You can get the ship arrested wherever the ship is jurisdiction. Bombay, Calcutta, Madras, wherever there is no limit. So that is the original jurisdiction where the High Court entertains in the matter here. So these are some of the examples. Now earlier the company law Bombay High Court had jurisdiction. Now it has gone to tribunal. Banking suits, the High Court had jurisdiction. It is now gone to DRT and NCLT. You all know that here. They are a tribe. They are the Constitution, the state and central government has appointed many tribunals which are looking after, because the High Courts are getting flooded with the matter. So these are essentially under the Arbitration Conciliation Act. Now arbitrators are appointed. Now, for the purpose of enforcement of your arbitration agreement, you come to here. The court defined is again a district court. Now, for the purpose of obtaining interim orders under section 9 before or after the arbitration is invoked, it is the High Court in Bombay City, which is the district court. You file petition for interim orders, for appointment of a receiver, injunction, any interlocutory order. Whether it is not necessary that you have invoked, given notice under section 21 for giving effect to for enforcement of the arbitration. Even before appointment of an arbitrator under section 11(6), which the High Court appoints normally, district court. Now you can go for interim orders, it is the High Court. But elsewhere, Pune city, Thane, you can go to a district judge. The principal district court, you can go and invoke your jurisdiction in the matter. So that is one. That is the jurisdiction of the Bombay High Court in matters which are called original jurisdiction, which is coming directly under section 9 of the Code of Civil Procedure, read with clause 12 of the latest patent. Please note that latest patent Bombay आपको CPC में मिलेगा, Bombay High Court rules में मिलेगा, and you will also find it in the original side of the appellate side of the rules, and in the CPC it is also annexed to all good books such as universal publication. Any of the books they have appended to it. Okay, these are the original suit matters which come under section 19. Now in the CPC, section 9 tells you jurisdiction, and section 15 कहता है कि every civil suit should be filed in a court of lowest grade and jurisdiction, having jurisdiction. So lowest grade means you cannot directly go to the Supreme Court under Article 131 of the Constitution, isn't it? You cannot go to the High Court under Article 226 of the Constitution. You cannot even go. So you have to go as per the jurisdiction which has been vested with the court. So for that purpose, the provisions of in the state of Maharashtra, the Civil Courts Act, you have to take into consideration the pecuniary, the enhancement of Pecuniary Jurisdiction Act and the Code of Civil Procedure, and the rules framed by the High Court, City Civil Court and Bombay High Court, you have to bear in mind in this regard. Please note that here. So it is this, the civil, you cannot go to a civil court unless you first determine the jurisdiction. So in the Code of Civil Procedure, for determining which court has jurisdiction, which matters can be taken up, section 9 tells you every suit is a civil suit which can be brought in a civil court. Now I gave you the illustrations of a civil court: a district judge, additional district judge, civil judge senior division, a junior division, small causes court of 1882 Bombay, and in Pune Varame, provincial small cause court of 1887 in Pune city, who are equivalent to, they are also called municipal courts. So these are the various courts. So you decide, like we have in the city of Bombay, apart from this High Court, City Civil, Small Causes Court, we also have a cooperative court exercising powers and jurisdiction under section 91 between members and societies on all person claiming through members, because nowadays there are a lot of housing societies. The disputes falling within the ambit of the Societies Act, they go to the cooperative court now, which is situated at Churchgate near KC College, isn't it? That jurisdiction is under section 91. All disputes between society and member and the person claiming under member touching the business of the society shall be filed in an exclusive jurisdiction of a cooperative court. And you cannot go to City Civil Court, Bombay High Court, Small Causes Court in that regard. So on the point of jurisdiction, there are lots of judgment. There were earlier we had a section called 9A in CPC with application for the state of Maharashtra, and that section was abused and misused by lawyers and everybody. Ultimately, the Supreme Court deleted it because on the ground that the court has no jurisdiction, a preliminary issue used to be framed. Time was wasted. Appeal used to go, second appeal, then High Court, Supreme Court. Because jurisdiction issue is covered under the CPC and Order 14. Order 14 may cover ho gaya. It is the discretion of a judge to frame it as a preliminary issue or not. समझे ना आप? So that is the point before the court, where the court. Then, so you understood the various mechanism, the scheme of the various civil court. in the state of Maharashtra and particularly in city of Mumbai. Then we have a courts apart from the consumer court. We have a consumer court but consumer court is not a civil court. It is in the nature of a tribunal. Please note that it's a tribunal, and it clearly says the act, when you read section 100 of the Consumer Protection Act, this act is in addition to and not in derogation with any other remedy which is available to the parties. So apart from the Consumer Act, you can still go to civil court if you are not satisfied that the consumer court is not given. Because consumer court ke paas, the provisions of the CPC and Evidence Act are not strictly applicable, though they may invoke it. Because they go by the principles of justice, equity, and good conscience in the matter. Okay. So that is the, then we have in the matter of, in the city of Bombay, apart from the consumer courts and this court, you also have tribunals such as CAT and MAT. MAT is a Maharashtra Administrative Tribunal. Service matters between the government of Maharashtra and the employees and central government employees, and state, we have CAT in the matter, that is it. Then we have labor courts exercising powers in the matter of, these are also tribunals in the, strictly speaking, under the Industrial Dispute Act, Workmen Compensation Act. So they adjudicate the dispute in the matter. Whether now we also have the Arbitration and Conciliation Act. Those who do not want to come to the court of law, which the trials are very, the prolonging takes longer time, speedy, not a speedy justice. So parties may invoke arbitration, especially in commercial matters, not in all matters. Certain, of course, the scope of the arbitration is enhanced now. So the Arbitration Act under, again, the provisions of CPC are strictly not applicable, but wherever if the procedure is silent, the arbitrators can invoke, there is no bar. Even the provisions of Indian Evidence Act are not binding strictly upon the, because arbitrators are tribunal. They are not a civil court. So whereas the provisions of CPC Evidence Act are strictly applicable to the courts which are civil courts, which I defined to you, the district court, civil judge senior division, a junior division, and the city of Bombay City Civil Court of 1948, small causes court under the 1882 Act. These are the courts. Of course, Family Court Act, where the family disputes also concern, is actually the provisions of CPC and CRPC are strictly not applicable. But in the absence of any rules in the Family Court Act, the CPC can be invoked. But as I see that here, most of the family court judges are invoking CPC in every walk of life here. There is no bargain. So the role of CPC as a procedural law plays a vital role in determining your civil remedies in the matter. So since the CPC is not defined the civil court, you must have the copy of a Civil Courts Act. Civil Courts Act of Maharashtra, if you are practicing in the city of Mumbai or Maharashtra, of 1869 Act. Or elsewhere you are practicing, every state has got its own Civil Courts Act. So there are Munsif Court, there are civil judges, junior division, senior division, everywhere. Almost all the acts are pari materia. The wordings are not different here. Okay. This is the original jurisdiction of the civil courts, how you determine it. Now, what exactly the CPC contains, today being an introductory lecture, and I will tell you furthermore a little more. So after the suit is filed in the civil court, after deciding the jurisdiction, a civil law is set into motion by the presentation of a document called plaint. PLANT, plaint, which we all of know. As young lawyers, you know that. The students, they want to know that what is a plaint is defined in the Order 7 of the Code of Civil Procedure. How the civil code is instituted, is set into motion, you have to see section 26 of the Code of Civil Procedure. A civil law is set into motion by presentation of a document called plaint. What does the plaint contain requirement is given in order 7. The name of the court, name of the party, the cause of action, the cause of action, the clause for limitation, the clause for jurisdiction, then the list of document, the relief which are sought. So you are required to maintain, and it should be supported by an affidavit. That is the requirement when you read it, order section 26 read with order 7. Section 26 mandate here. Every plaint should be supported by affidavit. I mean, why? Plaint is supported by affidavit in case you have made a false statement, you are accountable. There is a perjury provision under the provisions of Indian Penal Code, section, which section it is 192, 193, now BNS में आ गया उसके अंदर. So a person is accountable for whatever statement you are making. That is why affidavit is made mandatory for the presentation of a plaint. The moment the plaint is filed, in the plaint you must disclose the cause of action. Cause of action is nothing a bundle of facts. So in a suit for declaration, you may seek that here the agreement of sale which has been executed between the plaintiff and defendant tainted with fraud. Isn't it? Be declared null and void. Or the builder with whom you have booked the flat has committed breaches of the flat. You booked the flat for a consideration of 1 crore. He was supposed to give you within a period of 3 years' time. You paid the full money consideration, but the price having gone up, the builder has sold it to somebody else. Isn't it? Then what kind of a suit you will file? Again, suit for specific performance of a contract under section 10 of the Specific Relief Act for a declaration that the agreement of sale between the plaintiff and defendant is valid and subsisting, that the defendant is bound and liable to perform specifically the agreement and put me into possession and execute the conveyance. Failure to do so, the court receiver, court officer may be appointed to do this act. So these are the prayers normally queued. In the meanwhile, you seek an appointment of a court receiver. You seek an order of injunction. And a custodial agency is sought. So in the plaint, you put all these requirements. These are called cause of action. A cause of action must be clearly spelled out, and your suit should be within the period of limitation. Please keep with you as a young student a limitation bear act along with you. Suit for possession, suit for declaration, a suit for declaration and for specific performance should be filed within a period of 3 years from the date of the cause of action. The court will decide the cause of action accrued when? From the time you gave notice, from the time the defendant was required to perform the contract. That is a nature of one of these suit. You filed it before the court of law for specific performance of a contract. If the valuation of the suit is about 10 crore, it will come to the Bombay High Court in the original side. If the valuation of the property is about up to 10 crores, it will go to the city civil court. There are 2 city civil court in Bombay. One is a fort, another is in Dindoshi. The jurisdiction of the fort is from Colaba to Mahim. From Bandra onwards till Borivali, Daisar, all the suits where the property is situated, they will go to the Dindoshi court. Similarly, the court of small causes court is split into 2. One is the principal court at Dhobi Talao, where the properties situate from Colaba to Mahim, they come to the small causes court at Dhobi Talao, and the properties which are situated, landlord and tenant, from Bandra to Daisar, they will go to the small causes court branch of the small causes court Bombay. They are taken care of there. So once the plaint is filed, the reliefs are sought here. So order 7 is taken care of. Then the next step in the Code of Civil Procedure, what tells you that here, the writ of summons should be served within a period of 15 days upon the defendant. So you must take these steps and prepare the writ of summons. What is a writ of summons? Is defined under the provisions of Order 5 of the Code of Civil Procedure. How the summoning service is to be effected, either through the bailiff of the court or the registered AD of the court and personal services. Now, once the service is effected, then comes next the role of Order 8 of the Code of Civil Procedure, where the defendant is required to file written statement within a period of firstly 30 days. The first option is given 30 days. Extended time is 50 days. Further extended time 90 days. If within 90 days time you do not file your written statement, court may not take on record your written statement later on, and decree will be passed against you ex parte. Mean without any problem. You must immediately advise your client to start preparing your written statement. Sometimes many advocates waste their time by writing letters. You give me inspection, the documents. Unless and until it is given, I cannot file. You can wait for the document. Subsequently, you file the written statement after taking instruction from your client, denying the written statement, taking up the plea of jurisdiction. So, what are the pleas which are available to a defendant? Number one, the defendant can take up the plea that the court has no jurisdiction. The defendant can take up the plea that the suit is barred by limitation. Okay. The defendant can take up the plea that here there is no cause of action. When there is no cause of action, the suit is liable to be dismissed. Order 7, Rule 11 CPC empowers the plaintiff to take out application for rejection of the plaint at any stage. Okay. This is the remedy available to the defendant after receiving the writ of summons to file a detailed written statement. Now, once the written statement is filed, then the role of the court comes into play to read the plain written statement and documents and record to frame the issues. They are taken care of under Order 14 of the Code of Civil Procedure. Please note that. Under the Code of Civil Procedure, Order 14 के अंदर, the court frames the issues. Whether the plaintiff prove that he has any right title interest, whether the defendant prove that the defendant is a trespasser, whether the defendant state that the suit, whether the defendant submit that they claim that the suit is barred by limitation. So these are rival questions. The court will frame the issues for determination. They are framed under Order 14. Please note that here. But if the defendant or any of the parties want to take up the plea that the court has the plenary objection to the maintainability, can make an application that here to the court, the issue of jurisdiction goes to the root of the matter, may be decided as a preliminary issue. Earlier, Section 9A, which is now abolished. Now, under Order 14, Rule 2 CPC, the court can decide that. Okay. Now, in the event of the defendant having not filed the written statement in time, a decree has been passed, then there's a different remedy. You can come to the court of law for setting aside the decree. Now, once the issues are framed under the provisions of Order 14, then the next stage under the Code of Civil Procedure is the court normally direct the parties to take inspection of the document, file interrogatories, question answers, take inspection of the original record, so that one party is not taken by surprise to the various contention. So these are contained under the provisions of Order 11 and Order 13 of the Code of Civil Procedure. They are called pre-trial steps to be taken by the court of law in the Code of Civil Procedure Code. Okay. When it is 7 o'clock, you inform me, we'll stop it. Then we'll, after break of 3 minutes or 5 minutes, we'll take this ERP. Then I will continue till the stage of a trial. Then I will stop it here for today's lecture. Then the next lecture will continue further. Now, once the issues are framed, the directions are given by the court to exchange documents, to take interrogatories under Order 11, Order 13 CPC. When it is completed, then the stage will come for leading evidence of the parties. The role will come of Order 18 of the Code of Civil Procedure. Under Order 18, right to begin, the plaintiff filed a suit for a declaration that the defendant is a ranked trespasser, he is liable to be evicted. And plaintiff is entitled to the suit. A decree may be granted. Defendant will file a suit, will come out with a contention. I am not a trespasser. I am into possession, adverse possession, for more than 15-20 years. Under the provisions of Limitation Act by virtue of Section 27, a suit which is not filed within 12 years, suit is barred by limitation. So these are the contentions which are raised by both the parties. Then the next step will be leading evidence under Order 18 Rule 4. Now CPC permits. So here the evidence, how evidence is a 3 type: examination chief, cross-examination, re-examination, re-cross-examination. So role of Evidence Act come into play here. Okay, examination chief under 137 of the Evidence Act. Examination chief is your evidence of the plaintiff. That is required to be filed by affidavit under Order 18 Rule 4A CPC now. Now, once the affidavit is filed along with the list of documents, you give the copy to the other side. The court will say that the next step will be the other side to give a say on the list of documents, whether what documents admitting, what not admitting. So role of the Evidence Act will come into play here from section 135 to 136. These are called admissibility of document. Okay, admissibility of document ke baad, then the defendant has a right of cross-examination. Right of cross-examination under the Evidence Act, now under the BSA Act. See, Evidence Act theory is very clean. Your examination chief should be confined to the pleadings and the documents placed on record. Whereas the cross-examiner can travel beyond the pleading because he can impeach your credibility. He may take up the plea that the documents which are produced are sham, colorable, bogus. The evidence is not reliable. He may impeach your credibility. He may say that the document which is produced on record is a sham, bogus document. And you are in the habit of producing bogus documents. So cross-examination, the court will pass order with regard to admissibility under section 136 of the Evidence Act. Now under the BSA, some new section, we'll quote it. Uske baad, then cross-examination is over. If any point is left out, a new document is come, you have a right to take the liberty or leave of the court, seek permission to lead evidence in re-examination. I would like to re-examine the plaintiff because some new documents are come on record. For example, at the time when the suit was filed, probate was not obtained. Now the Bombay High Court or District Court has granted a probate which I would like to produce before the court to substantiate the contention that I am the owner of the property. So that can come at the time of examination, chief probate was not ready. So the court will permit it. Under the provisions of 138, there's a permission can be sought for a clarification or additional evidence can be done. Once that document is come on record by virtue of a re-examination, other side will be given an opportunity to re-cross-examine you. That is called re-examination of the witnesses. So that way, the list of witnesses is required to be given by both the parties under Order 16, Rule 1 CPC. Please note that. A list of witnesses, so that you are not taken by surprise. You have a right to make inquiries about who are the persons sought to be examined, to know their demeanor, whether they are genuine person or bogus person. Both the parties are under obligation. In the city of Bombay, I have seen practices that here district court people are more careful in filing the list of documents. Now the courts in Bombay also are becoming more and more vigilant, directing the parties file the list of documents. Formally such a rule. But you have a right to examine a new witness without such list being added if the witness is necessary for your case. That is Order 16 ke andar provision hai. Okay, please note that. So once this procedure is done, then the other side defendant has a right to lead evidence. Yeah, other side has a right to. Similar provisions will come into play. List of document, examination chief, cross-examination, re-examination. Okay, under the Evidence Act, both the parties, you have to lead evidence cross-examination subject to the rules and regulation, and the court has power to ask question under 165, irrespective of whether the question is relevant or irrelevant. Trial court's powers are very vast. Now, once that is done, when the trial is closed, when both the parties have finished evidence, they have to give a purchase document called, we are closing the evidence, the matter is set for arguments. Now, provisions of Order 18, right to begin, read with Order 20 will come into play. You also have a right to file written arguments. So, the party normally who close the evidence last will have a right to begin first. These are the rules framed, the inbuilt rules pursuant to various Supreme Court and High Court judgment. It may not be there in CPC or Evidence Act. Who should begin first? Argument. The person who closes the evidence last begins it. Okay, then the matter is set down. The post passes a judgment under the provisions of Order 20 of the Code of Civil Procedure. If the judgment goes against you, make an application immediately that the operation of the order may kindly be stayed to enable you to go in appeal. Okay, that provision is there under Order 41, Rule 5.2 made. So at the moment today, we stop the Civil Procedure Court, and after 5 minutes break, we'll take the CRPC. Then next week again, we'll continue the CPC lecture. Okay, please take a break. Is it okay? Have you understood, all of you? Anybody has any queries so far?
No, sir.
No queries. Okay. Any queries, you may ask me after 5 minutes. Now I will take briefly after 10 minutes the BNSS, the CRPC, new CRPC, which will be useful for the student and also young student. Okay. For 5-10 minutes.